Judges have ruled Florida's current age limit for concealed carry is unconstitutional.
The court now has struck down Florida's ban on concealed carry for 18 to 20-year-olds, calling it unconstitutional.
We don't see any reason to change those laws.
You can have it on the sidewalk, not in the street. There were so many different variations to where you can carry, and it was ridiculous.
Residents tell me they're glad this ban is no more.
Who do these folks think they are?
Reclaiming the Second Amendment rights of Floridians. And we are just getting started. We also brought back open carry for the first time in nearly 40 years.
A Florida appeals court just ruled that 18-year-olds have the constitutional right to carry a concealed weapon in public. The Attorney General of Florida celebrated the decision, and the law the court just struck down was named after the 17 students and teachers lost at Marjory Stoneman Douglas High School. That is where Florida gun law stands on June 17, 2026. Florida's First District Court of Appeals struck down the state's under-21 concealed carry ban, ruling it unconstitutional under the Second Amendment. Any Florida resident who is 18, 19, or 20 years old can now apply for a concealed carry permit. This is not pending. This is not a proposal. It is the current law in the state of Florida issued by a court as of this week. To understand how this happened, you have to go back to February 14th, 2018. A gunman walked into Marjory Stoneman Douglas High School in Parkland, Florida, and took the lives of 17 people in 6 minutes. He was 19 years old. He had purchased his AR-15 legally at age 18 under federal law. At the time, federal law allowed licensed dealers to sell long guns to buyers as young as 18. In the weeks that followed, the Florida legislature passed the Marjory Stoneman Douglas High School Public Safety Act. It was one of the most significant gun control measures any Republican-controlled state had passed in decades. Among its provisions, anyone purchasing a firearm in Florida and anyone applying for a concealed carry permit must be at least 21 years old. The NRA filed suit against that law almost immediately after Governor Rick Scott signed it. That lawsuit took 8 years to reach this result. To understand why the court ruled the way it did, you have to understand what the Supreme Court did in 2022. Hohen in New York State Rifle and Pistol Association v. Bruen, the Supreme Court fundamentally changed how courts evaluate gun regulations. Before Bruen, courts applied a two-step test that weighed government interests against constitutional rights. Bruen eliminated that balancing test entirely. Under Bruen, a firearm regulation is only constitutional if it is consistent with the nation's historical tradition of firearms regulation at the time of the founding. If a regulation has no clear historical equivalent from the late 18th or early 19th century, it cannot stand. That is the test now. When Florida's courts applied the Bruen test to the under-21 carry ban, they found no historical tradition of restricting 18, 19, 20-year-olds from bearing arms. In 1791, 18-year-olds were considered adults in every legal sense. They signed contracts, owned property, served in militias, and carried firearms. There was no founding-era law that barred them from keeping or bearing arms. The Bruen framework made the Parkland-era restriction nearly impossible to defend from the moment the Supreme Court issued its ruling. Courts across the country have been applying that test and knocking down gun laws ever since. Number one, they questioned the legality of it, that it would never stand up to the muster of law for anyone who decided to challenge it. And I have to be honest with you, I never spoke to anyone who literally took it serious. This ruling does not exist in isolation. It is the third major Florida gun law to fall in less than a year. In September 2025, separate Florida court struck down the state's open carry ban. That was the law that had prohibited Floridians from visibly carrying firearms in public spaces. Attorney General Utmeyer responded to that ruling not by appealing it, but by declaring open carry the law of the state. In October 2025, additional Florida gun laws were ruled unconstitutional in separate proceedings. What you're watching is a systematic legal dismantling of the gun restrictions Florida passed after Parkland, happening challenge by challenge, court ruling by court ruling. The legislature passed a suite of laws. The courts are removing them one at a time. A trial court struck down the concealed carry ban in October 2025. Appeals court affirmed that decision in June 2026. The legal road does not end here. The ruling can still be appealed to the Florida Supreme Court or the United States Supreme Court. But with Bruen as the controlling precedent, and with the Trump administration's Justice Department showing no interest in supporting state gun regulations, the legal headwinds for reviving the under-21 restriction are severe. Parkland survivors and gun control organizations have called the ruling dangerous. They point to the same data every time a ruling like this comes down. In the United States, firearms are the leading cause of death for people aged 1 to 19. That milestone was crossed in 2020 when gun deaths surpassed car accidents, the top cause. 18 to 20 age group specifically has the highest rate of firearm homicide victimization of any age bracket. These are the people the Florida law was designed to keep from carrying concealed weapons in public. These are the people who can now legally do so. The response from gun rights advocates is equally direct. The Constitution does not have an age carve-out for adults between 18 and 21. The 26th Amendment recognizes 18-year-olds as full voting citizens. Selective service registration applies to them. Military service applies to them. Criminal courts try them as adults. The Second Amendment, gun rights advocates argue, cannot be the one place where adulthood begins at 21. That argument won in Florida's First District Court of Appeal. One detail that sharpens the legal picture, Bruen did not just change the test court's use, it shifted where the burden of proof sits. Before Bruen, the government defending a gun regulation had to show the law served an important interest. After Bruen, the government must affirmatively prove the regulation matches a historical tradition from the founding era. Florida's lawyers were in the position of having to locate an 18th century law restricting 18-year-olds from carrying in public. That law does not exist. The moment Bruen was decided, the under-21 carry ban was on borrowed time. The ruling on June 17th was not a surprise to anyone watching the legal landscape. It was the expected outcome of a Supreme Court decision made 4 years earlier, landing in a state whose Attorney General had already decided the law was not worth defending. Attorney General Moody did not simply decline to appeal, he celebrated. He announced the ruling. He framed it as a win. The elected official responsible for enforcing Florida law publicly applauded the removal of a law passed in direct response to the shooting that gives this law its name. When a state's attorney general refuses to defend a law in court, the law's opponents face a weakened or non-existent defense. The Parkland law did not get a full-throated defense in the appellate courts. It got a state government that had already decided it should not survive. Thank God, Florida now joins a growing list of states where the post-Bruen legal landscape has rolled back regulations that courts previously upheld for years. Illinois, California, Maryland, New Jersey, Washington. The Bruen decision created a new constitutional standard, and it is reshaping the legal landscape one ruling at a time. The students who survived Parkland were 14, 15, 16 years old in 2018. The youngest of them are now in their mid-20s. They watched the law passed in their school's name get challenged, weakened, and struck down by an appeals court in the state where it happened. Thank you for watching. See you in the next video.